A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a significant legal development, the Wisconsin Supreme Court has struck down the state's 176-year-old abortion ban, ruling in a narrow 4-3 decision that the ban was superseded by more recent legislation governing abortion procedures. This ruling comes amidst a broader national debate on reproductive rights, following the U.S. Supreme Court's decision to overturn Roe v. Wade in 2022. The ban, which was enacted in 1849, classified the intentional destruction of an unborn child as a felony, effectively making it illegal for anyone other than the mother to terminate a pregnancy. It remained in place until 1973 when Roe v. Wade legalized abortion across the United States, nullifying such state laws. However, the ban was never formally repealed, leading some conservative lawmakers to argue that the recent Supreme Court ruling reactivated it. Wisconsin Attorney General Josh Kaul, a Democrat, filed a lawsuit challenging the ban, asserting that it was rendered obsolete by subsequent laws that regulate abortion, including a 1985 statute that permits abortions until the point of viability. This law acknowledges that some fetuses can survive outside the womb after 21 weeks of gestation. The case saw a clash between Kaul and Sheboygan County District Attorney Joel Urmanski, a Republican, who defended the 1849 ban. Urmanski contended that the old ban could coexist with newer abortion regulations, similar to how different penalties for the same crime can exist simultaneously. In 2023, a Dane County Circuit Judge ruled that while the 1849 ban criminalizes feticide, defined as the killing of a fetus without the mother's consent, it does not outlaw consensual abortions, allowing abortions to continue in the state. The Supreme Court's recent ruling provides greater assurance to healthcare providers and patients regarding the legality of abortion in Wisconsin. The court's liberal majority, which has been bolstered by recent elections, was expected to overturn the ban. Justice Rebecca Dowlett, writing for the majority, stated that the comprehensive legislation enacted over the last 5 decades regarding abortion so thoroughly covers the entire subject of abortion that it was meant as a substitute for the 19th century near-total ban on abortion. The dissenting opinion, voiced by Justice Annette Ziegler, criticized the majority for what she deemed a jaw-dropping exercise of judicial will, suggesting that the ruling was influenced by the justice's personal preferences rather than legal precedent. The ruling is particularly significant as it solidifies abortion rights in Wisconsin, especially following the contentious political climate surrounding reproductive health. The court's decision also comes at a crucial time, with the recent election of Susan Crawford, a Democrat, who has yet to be sworn in but is expected to play a pivotal role in a separate lawsuit challenging the constitutionality of the 1849 ban, which is currently pending before the court. This landmark ruling is likely to have lasting implications for reproductive rights in Wisconsin and may set a precedent for similar legal battles across the country as states grapple with the fallout from the U.S. Supreme Court's decision to overturn Roe v. Wade. As the legal landscape continues to evolve, the focus now shifts to how this ruling will influence the ongoing discourse on abortion rights and access in Wisconsin and beyond. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.